This program is a fictional dramatization of what may have transpired during the trials of the students who had been arrested during the nonviolent sit-ins that took place 50 years ago in Nashville, Tennessee, in protest of the segregated lunch counters in downtown Nashville. The following trial reenactment was written by Nashville attorney Gary C. Shockley for the Nashville Bar Association's Law Day celebration, commemorating the 50th anniversary of the date when Nashville's lunch counters were officially desegregated. The reenactment is one part of the Law Day celebration held in honor of the brave and dedicated student protesters who heroically fought for their civil rights and to commemorate the achievements of the attorneys who fearlessly undertook representation of the student protesters because it was the right thing to do, even if it might not have been the popular thing to do. This dramatization does not reflect the actual opinions of the participants regarding segregation or the events of 1960. We're lucky, you and me. It's just after 2:00 p.m. on Monday, February 29th, 1960, and City Court has just convened. All these seats here in the gallery have been filled hours ago by people who had come to see the sit-in trials. The regular city judge, George Doyle, he had the court officers clear the courtroom just a little while ago so that all 81 defendants would have a place to sit, and only then let in the regular folks like you and me. The rest of the people, they're just a part of the crowd that you pass on the way in, over 1,000 strong out in front of the courthouse. If you listen carefully, you can hear them singing the national anthem and freedom songs even right here in the courtroom. And clearing the courtroom was not all Judge Doyle did. First, he dismissed the loitering charges, and then he recused himself. He appointed Special Judge John I. Harris to preside over these cases. Judge Doyle holds an elected position, and he's savvy enough to know that there's no right way to handle these cases politically. On one hand, you have the city government, the downtown merchants, the police, and the banner. On the other, you have the Negro ministers, the Fifth Ward voters, and the Tennessean. In fact, the students themselves are being represented by two city councilmen, Attorney Z. Alexander Luby and Attorney Robert Lillard. Judge Doyle was more than happy to hand these cases over for Special Judge Harris to deal with.
All rise. The Honorable City Court for Nashville, Tennessee, Special Judge John I. Harris presiding, is now in session. Draw nigh and you may be heard. God save the United States, the state of Tennessee, and this honorable court. You may be seated.
All right, good afternoon, gentlemen. I believe our first case is one of the disorderly conduct charges from the altercations on Fifth Avenue last Saturday. Is the city ready to proceed, Mr. Leaver?
Yes, Your Honor. We have amended warrants charging each of the 81 defendants with disorderly conduct on Fifth Avenue last Saturday.
I see. Now, did Judge Doyle sign those new warrants before he left the bench today?
No, Your Honor. Judge Doyle dismissed the loitering charges and made notes as to the sufficiency of the original warrants, but he didn't sign them.
I see. Well, all right then. Just have the bailiff bring them up here so I can sign them so we can get underway.
Judge, we'd like to be heard before you issue these warrants.
Well, Mr. Luby, are you representing some of these defendants here?
I am, Your Honor, along with Avon Williams, Robert Lillard, Hoynes Enix, and Adolfo Birch, and some others. I am lead counsel for the defense of these students.
And you'd like to be heard on these new warrants that are being presented by Mr. Leaver?
Yes, Judge. In fact, we'd like to make two motions. One as it relates to the charging documents, and the other has to do with your appointment as special judge in these cases.
Well, very well then. Let's talk about the one about me first.
We wish to note respectfully the defendant's objection to your serving as special judge in these cases. Judge Doyle, as you know, was present here just a few minutes ago. In fact, he dismissed 80 loitering cases against these young people and advised Mr. Leaver that the warrants were defective and that the remaining disorderly conduct charges as well. Clearly, Judge Doyle is available and able to serve as city judge today. Section 241 of the city charter says that the city judge may appoint a special judge in the case of his temporary absence, incompetency, or inability to serve in any case. The record here does not show any absence, incompetency, or inability to serve on the part of Judge Doyle. The charter does not allow for appointment of a special judge absent one of those three circumstances. In addition, we think the people are entitled to the services of the judge they elected, as are these young people who are with us today. There is simply no basis for disqualification or recusal on the record, and we believe the regular judge should try these cases just like any other on the court's docket. And finally, Judge Harris, we also make an objection to your service as special judge in this case. The defendants and their lawyers have been informed that you expressed an opinion on the merits of the case yesterday, Sunday, to a member of the bar, one day after the arrest and one day before the trials. We have been told that you expressed an intention to convict on the charges and, if possible, to bind the defendants over to the grand jury for additional criminal state charges as well. The 14th Amendment and the Tennessee Constitution entitle these defendants to a neutral judge who has not formed an opinion about their guilt or prejudged the case prior to hearing the evidence. Your Honor is a very experienced lawyer, and I'm sure you can appreciate the delicacy of our objection, as well as the necessity that we make it. So on both of those grounds, we object to the employment of a special judge just to try these 80 sit-in cases. As the evidence will show, these young people have never been arrested before, have never seen the inside of a paddy wagon or a jail. They're college students. Some of them are from the American Baptist Theological Seminary and are even ordained ministers. Many of them are not from here in Nashville. So naturally, their parents are worried about them, as are their teachers and their friends. So it's especially important that we show their families, that we show the whole country, that we're going to ensure they get a fair trial and follow our regular procedures as we get underway here with their regular judge, the one that was elected by the people.
So let me get this straight. There's two parts to this motion. First, you think Judge Doyle should be required to preside, and then second, you think I've prejudged these cases. As to Judge Doyle, I have no power to compel him to serve and no grounds to question the sincerity or sufficiency of his reasons for appointing a special judge. As I understand it, he was out of town on Saturday when these warrants were actually issued and feels that he should not preside. I believe that constitutes absence or inability under the charter. In any event, that's his decision to make, and he's made it. I'm not going to second guess him. Second, as to your charge of bias, I'm not sure what your specific allegation is, Mr. Looby, but certainly the vague hearsay statement that I said something to some unidentified lawyer yesterday isn't sufficient to disqualify an appointed special judge. Now, if you'd like to name your source and bring him forward into this courtroom to give us the details, I'll be happy to address them. Otherwise, I don't believe you've shown any grounds that would affect my ability to hear these cases. If the defendants are unhappy with my rulings, well, they can always file a bond and they can appeal it to the circuit court. Now, did you also want to address these new warrants?
Yes, we did, Your Honor. With respect to the warrants, Mr. Leaver has been unable to produce the original warrants that Judge Doyle suggested were defective We contend that if the warrants are insufficient to charge loitering, they are necessarily insufficient to charge disorderly conduct. If the warrants are defective, they are defective, and the remedy is to dismiss all the charges, not just the trespass charge. The city should not be allowed to arrest these young people, these young men and women, hold them in jail past midnight, and then bring them in here, have them seek bond based on these faulty warrants.
Can I address that, Judge?
Oh, well, you can. I don't think it really matters what he says, but
well,
go ahead.
I would like to mention just a minute. I mean, Mr. Luby's correct that we haven't been able to locate the original warrant from Saturday, but I think that's irrelevant. We thought it was in the booking room. We haven't been able to find it. But I think when we submit the new warrants and you sign them, we'll be ready to go. Each of these new warrants identifies one of these 80 defendants and specifies a violation of Section 26.16 of the City Code, which prohibits disorderly conduct. Mr. Luby and his clients will already have notice of the charges, and they'll have ample opportunity to confront the witnesses against them and to present evidence of a defense.
All right, well, I believe that's sufficient. That motion will also be denied. Bailiff, can you pass those warrants up here and let's get going?
Yeah.
All right, now, while I'm signing these, which of these cases would you like to hear first, Mr. Leaver?
If Your Honor, please, it's State of Tennessee versus Lewis Hunter.
I see. Very well. Is Mr. Hunter present, Mr. Luby?
He is, Your Honor.
All right, that's great. Let's proceed then, Mr. Leaver.
May it please the court, Defendant Hunter here is one of 83 students, 78 Negro and 5 white, who were arrested on Saturday, February 27th, at the lunch counters of Walgreens, Cress, W.T. Grant's, McClellan's, and Woolworth's on 5th Avenue North. Hunter and the other defendants were part of a group that had been disrupting the business of these dime stores over the last 2 weeks, since February the 13th. Their pattern has been to enter the store and sit at the lunch counters where they are well aware that they will not be served under a long-standing policy of each of these stores. Notwithstanding that knowledge, the defendants have refused to leave the lunch counters even after they were closed by the stores due to the disturbance. Hunter and the others have continued to sit at the counters, which keeps their regular customers away by intimidation and has threatened to provoke violence. Now, last Saturday, the inevitable, foreseeable, and intended result of this conduct happened. When Hunter and his Confederates shut down the lunch counter at Woolworth's and refused the manager's request to leave, they became involved in a fistfight with bystanders. Blows were exchanged. People were knocked to the floor. There was a dangerous disturbance inside the store. I should also note that there was a large throng of people in the street that day and that the police were concerned that this violence could spread to the larger crowds outside. So the police responded promptly to the free-for-all inside the store and arrested Mr. Hunter and the others. They were charged with disorderly conduct under Section 26.16 of the City Code, and we believe the evidence will show that they are guilty of that charge, Your Honor. Thank you.
All right, Mr. Leaver. Mr. Luby?
Your Honor, Mr. Hunter is a student at Fisk University and is originally from Decatur, Alabama. He has an unblemished record at school and is studying mathematics with the goal of becoming an architect or a pilot. Mr. Hunter and these other college students have been exercising their right to assembly, association, and free speech over the last few weeks in downtown Nashville. They've been protesting the policy, which will gladly take their money at the cash register, but refuse to let them sit down and eat at these lunch counters that are within these stores. These very same lunch counters where all other customers are free to sit down and eat at. Like the students in Greensboro, North Carolina, and across the South, Mr. Hunter and his friends believe that it is immoral for these businesses to treat American citizens in such a fashion. As a result, they have chosen to pursue a peaceful, disciplined, respectful, and lawful means of protest. Mr. Hunter is one of several students, black and white, who sought service at Woolworth's lunch counter on Saturday. When refused service due solely to the presence of Negroes in their group, they continued to sit at the counters to make clear in a nonviolent and orderly fashion their objection to this segregation. They studied and read. They did not chant or sing or take any action that would interfere with the normal business in other parts of the store. They did not intend to incite or provoke anyone to violence, nor to intimidate any employee or customers in the store. If left alone, they would have continued their protest until they peacefully departed for a rally at First Baptist Church, just as they had done on 2 prior Saturdays. But unfortunately, they weren't allowed to do so. Instead, groups of young toughs were allowed into the store to harass these young people. The students, including the young women among them, were cursed and then spat upon. They had cigarettes burned into their clothing, had their hair pulled, had sugar and flour and ketchup poured over their heads. They were insulted. Mr. Hunter and others, when they refused to respond to these taunts and threats and insults, were physically pulled from their stools and beaten to the floor, while the mob kicked them. After beating the students, the white toughs, as it were, left the stores, and only then did the police arrive. Rather than chase their assailants, whom I would submit are the real criminals here, the police arrested Mr. Hunter and his friends. We believe that the evidence will show that Mr. Hunter and the other students were not disorderly, did not intend to, and did not, in fact, create a disturbance of any kind. We believe that their actions were well within their rights of free expression, assembly, and association, granted to all citizens by the United States Constitution, and they must be acquitted of these charges.
All right, Mr. Leaver, call your first witness.
Your Honor, the city is going to call Sergeant Ernest Watson, please.
Place your left hand on the Bible, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. You may be seated.
Would you state your full name, please, Sergeant?
My name is Ernest P. Watson. I've been a sergeant on the Nashville Police Department for 15 years, and I'm assigned to the downtown sector, which includes the department stores on Church Street and the 5 and 10 cent stores over on Fifth Avenue.
And were you working last Saturday, February 27th?
Yes, sir. Every patrolman was on duty last Saturday.
And why was that?
Well, there have been demonstrations for the past 2 Saturdays, and the crowds were getting bigger, rowdier, seemed like every week. We were assigned by Chief Hosey to go to Fifth Avenue and maintain order and keep the street clear so that traffic could go through.
And so tell us what happened then.
Well, you mean on that Saturday?
On that Saturday.
There was quite a crowd. I would say maybe as many as 2,000 people out there that day. They were both colored and white. And a lot more people than normal for this time of year. There were lots of Negroes, both young people and some older people. There were also lots of white people. Some of them were shopping. Some of them were just there probably to see the show. And some of the younger men that came were clearly looking for trouble.
What do you mean by that?
Well, there was lots of name calling. There was taunting, threats back and forth between the whites and the Negroes. And we had our hands full keeping these groups apart and keeping the traffic going.
Okay. Well then, Sergeant, what happened next?
Well, according to my report, all of a sudden there was a lot of activity over at Woolworth's store. People shouting and jostling around. A group of the young white guys that I talked about came running out, and several of us officers ran into the store to see what was happening. We were directed upstairs to the mezzanine. When we got there, we found several of the students on the floor, others with their clothes torn or cuts and bruises. It was pretty clear that they'd been fighting in the store. We spoke to the store employees and confirmed that there had been a fight and that the Negroes and whites were sitting at the lunch counters and that they had been involved. And we placed all the participants in the store under arrest and transported them downtown for booking.
All right, sir. And now, was that the end of it?
Oh, no, sir. That sort of thing happened all day. As soon as we had one group of kids out of the store, another group would come in the back door and sit down at the same stools. They had it all planned out. We were there all afternoon, arresting them, hauling them outside of the wagon, going back for another load.
And were there any more disturbances after you took Mr. Hunter downtown?
Seemed to me that it was all one big disturbance. We were breaking up fights, separating groups, just trying to calm things down.
And what effect did this have on the stores?
I really don't think they had much business, Mr. Leaver, regular business, I mean. That day, I didn't see many people doing any shopping in the middle of all that mess.
Okay. Thank you, Sergeant.
Mr. Luby?
Good afternoon, Sergeant.
Good afternoon.
Now, you were in the street keeping the peace when the assault took place on the inside at the counters. Is that right?
Yes, sir.
So you didn't see who threw the first punch?
No, sir, I couldn't see the lunch counter from outside the store.
In fact, you didn't see who threw any punches?
No, it was all over by the time we got there.
So you can't say if Mr. Hunter here threw any punches at all, can you?
All I can say is he was pretty scuffed up. And when I saw him lying there next to the lunch counter.
Scuffed up? As in somebody had attacked him, perhaps?
I recall his shirt was pulled out, his suit was torn. I think there was dust on his trousers. I'd say he got the worst of it.
You didn't see any cuts or bruises on his hands, did you?
I didn't look at his hands.
You didn't see any cuts or bruises on his hands, did you?
No, sir.
And the other students, were they all seated at the counter when you arrived?
Either at the counter or a table or two.
They weren't fighting when you got there.
As I recall, they were reading. One was holding a handkerchief on his head, and some of the others were kind of looking after him, I believe.
And none of the white men who were involved were arrested?
Well, they were all gone by the time we got there.
They ran past you in the street, didn't they?
They did come running out of the store pretty fast.
But none of the officers followed them?
Some of the officers might have, but my job was to go in the store and find out what had happened.
The fact is, there was no interest to go into the stores before these students were assaulted, was there?
My job was to keep calm in the store and on the street, not to babysit your clients, Mr. Luby. Chief Hosey did not want the presence of policemen in the stores to cause any distraction.
Sergeant Watson, there were no disturbances on Saturday, February 13, when the students first came to the lunch counters, was there?
None that I'm aware of.
And there were no disturbances on the 18th?
No, none that I'm aware of.
And none on February 20th?
None that came to my attention.
So these students had been at the lunch counters on 3 prior occasions with no trouble?
Well, I wouldn't say there was no trouble. They had to close those lunch counters each of those days.
But there were no assaults, no fights?
That's correct.
Thank you, Sergeant. I believe that's all I have.
Yes, sir.
I want to thank you, Sergeant Watson. You're excused. Call your next witness, Mr. Leaver.
Your Honor, the city calls Charles T. Henry to the stand.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may be seated.
You're Charles T. Henry, is that correct?
Yes, sir. I go by CT.
And what do you do for a living, sir?
I'm the manager of the Woolworth store at 221 Fifth Avenue North.
And can you tell me a little bit about your store? What kind of business is it?
Yes, sir. We're a part of a national chain of general merchandise stores, what you might call dime stores. We offer toiletries, cosmetics, toys, school supplies, candy, gum, that sort of thing. Just any general merchandise people might need.
And is there any difference between your store and, say, some of your neighbors like Harvey's or King Sloan?
Yes, sir. We don't sell any large appliances or clothing or any of the more expensive items. You got to go to Harvey's or Sloan down on Church Street for that sort of thing.
Now, what about food? Do you have food service there?
Yes, sir. We have 2 lunch counters, one on the street level and one upstairs.
Now, this food service, is that an important part of your business?
Oh, very important. We have folks who come in to eat or get a cold drink, and while they're there, they may pick up an item or two from the aisles, or we have people who come in for lunch to do a little shopping, and they'll stay and have a hamburger. It's a profitable part of our business.
Now, tell us about your competition.
Well, there's plenty of it, that's for sure. Right near us, we've got other general merchandise stores, dime stores like Cress's, W.T. Grant, McClellan's, Walgreens. Plus, just around the corner on Union is the McGrath drugstore. They sell merchandise much like we do, plus they get the prescription business as well.
Now, do all these competitors have lunch counters?
Yes, and the large department stores I mentioned have lunch counters. They sell some of the same merchandise we do.
Now, you said that these lunch counters are a profitable part of your store. Has that changed any lately?
Yes, I'm sorry to say that it has. It all started a couple of weeks ago when these young Negroes came in and disturbed our lunch counter business.
And so your business has fallen off, is that correct?
Yes, sir. It's fallen off pretty sharply.
Now, when did all this start?
That started on the 13th. I remember because that's Valentine's weekend, and we normally do a big business in cards, candy, that sort of thing. But the business really dropped off badly because of those folks.
Now, on the 13th, exactly what happened? How did things get started on that day?
Well, there were a group of young Negroes came into the store and they started browsing.
All right, anything wrong with that?
No, sir. We have a good number of loyal colored customers.
Okay, go on, please.
Well, after they'd bought a few items, they sat down at the lunch counters, and the waitress told them that we don't serve Negro customers at this lunch counter, but they refused to leave. So all I could do was, close the lunch counter. I was afraid there was going to be an altercation, maybe with our employees or with some white customer who might want to have lunch.
Okay, and after you closed the counter, did the Negroes leave?
No, they just continued to sit there. I put up a sign, turned out the lights, and I personally told them that they would have to leave, that the lunch counter was closed, but they just kept sitting there.
So when did they finally leave your store?
Oh, I'd say around 2 o'clock that afternoon. We didn't do much lunch business that day.
And what about the rest of your business? How did it affect the rest of the business in the store?
Well, like I said, Valentine's weekend's a big weekend for us, and I think maybe the white customers knew that there was something going on, and they stayed away. We had a lot less receipts that weekend than we normally would.
Now, did it happen again after that first time on the 13th?
Yes, sir, it certainly did. The following Thursday, the 18th, the same thing happened again, only this time there was also folks sitting in at Cress's and W.T. Grant and Walgreens, I believe.
Okay. So what happened at that time?
Well, the same thing. They came in, browsed the aisles, picked up a few items, sat down at the lunch counters.
Now, you say students. Was it the same Negroes as the time before?
Well, I can't say it was the same, but it was, basically the same group of young Negroes. Plus, there were a few young white people, boys and girls there as well.
Okay, so that's twice in 1 week you had to close your lunch counters. When did it happen next?
The following Saturday, the 20th, it affected our business pretty significantly once again.
And it was the same thing?
Yes, sir, exactly the same.
Only was it larger this time?
Oh, very much larger. I don't know, there must have been 300 of them come and occupy all the lunch counters on Fifth Avenue and probably on the department stores as well.
And how long, do you recall, were they in your store?
Oh, they were there from right before noon till about 4 o'clock, so good 4 hours. We obviously lost a lot of business that day.
Right, okay. Now, Mr. Henry, did you ever talk to the police about this?
Well, I certainly did. This was killing my business. But I spoke to the detective, and they said they couldn't do anything unless there was a disturbance.
And had there been any disturbance up to that time, Saturday the 20th?
No, nothing physical, but I was afraid there's going to be some kind of altercation with my employees or other folks who wanted to have lunch there.
Mm-hmm. And you saw things building up, is that correct?
Yes, sir, I certainly did. There were a bunch of white youths, what you might call toughs, out on the street yelling and taunting the Negroes, but there was a large police contingent out there, so it kept them separated.
But now, did eventually you have trouble in your store?
Yes, sir, certainly did. 2 days ago, Saturday the 27th.
And tell us about that.
Well, pretty much the same thing. The Negroes came in, browsed, got a few items, sat down at the lunch counters, both on the street level and up on the mezzanine. And then all of a sudden, these white boys, toughs I call them, rushed in and started beating folks and pulling them off the stools and wrestling on the floor, that sort of thing.
And this was both downstairs and in the mezzanine where this all occurred?
Yes, sir. I'd actually gone up to the mezzanine to check on there on the lunch counter there, and I don't think the white boys knew that there were Negroes up there at first, but then they came rushing up there, and that's when all the pummeling and everything started up there, and people were knocked to the ground and bleeding, and women were crying.
And what did you then do?
Well, I warned them that I was going to go call the police, and pardon me, I started downstairs to get the police, but then they heard someone yell, "The police are coming," and all the white men ran out of the building.
And what about the students?
Students, they just kind of sat there, dusted themselves off, helped each other back up on the stools. I couldn't believe it. There were people crying, people with blood on them.
And they sat back down at the
They sat back down, yes, sir.
Now, what did the police do when they got there?
Well, they arrested them. One by one, they put them in handcuffs and put them in the paddy wagon.
Arrested the Negroes?
Yes.
Okay. And when they arrested them, this first group, was that the end of it on Saturday?
Not hardly. There was another group came in right after them, and then they would arrest them and put them in another paddy wagon and take them off. The jails must have been really full.
Now, what effect did all this commotion have on your business?
Well, it practically shut us down, I can tell you that. I remember one elderly white lady had been sitting at the counter when the Negroes came in to sit, and she got up and went to the powder room, and some young Negro girls followed her into the powder room, and she came running out yelling, "Negroes, Negroes everywhere." I don't think she's going to be in our store anymore.
Now, Mr. Henry, before last Saturday, how many fights have you had at the lunch counter at Woolworth's?
None that I can recall.
Thank you. I believe that's all I have, Your Honor.
All right, thank you, Mr. Henry. You may step down. Now, having heard all of the evidence...
Forgive me for interrupting you, but I would like to examine this witness.
Well, all right. I'll let you go ahead, Mr. Looby, by all means. But now, bear in mind, Mr. Looby, if you would, we've got 83 of these cases to get through today, as well as our regular docket. So please move along.
I'm very conscious of the number of cases, Judge. I do wish to cross-examine Mr. Henry and any other witnesses to Mr. Leaver calls. I would like our clients to testify, and I certainly want to be heard in closing prior to any ruling by the court on these charges.
All right, so let's get on with it. We'll be here till midnight if we don't get on with it. Let's go a little faster.
Mr. Henry, you said your store has many Negro customers?
Yes.
And they buy all sorts of things in your store?
Yes.
You said you carried, I believe you said, something about toiletries and cosmetics, magazines, candy, all of that sort of thing?
Yes.
And all of that is for sale to your Negro customers?
Certainly.
In fact, some of these young Negroes here in court today, they bought some of those items as well, didn't they?
Yes.
So you don't have any policy against taking money from Negroes who shop in your store?
No.
Now, the lunch counters, there's a different policy applied there, correct?
Yes, we do not serve Negro customers at our lunch counter.
Not even if they're one of these loyal colored customers that you testified about earlier?
No, we don't serve Negro customers at our lunch counter.
Okay. So a Negro can buy merchandise and pay for it at the cash register, but you can't stop in for a quick bite of lunch like your white customers.
That's right.
You said Woolworth's was a national chain. There are Woolworths that serve both Negroes and whites at lunch counters, aren't there?
Yes, we follow local custom. There are stores that serve both whites and Negroes, but like I say, we follow local custom. Here in Nashville, we have segregated lunch counters. All the restaurants, lunch counters do. Everybody in Nashville knows that.
And you aren't going to change those customs, are you, sir?
Well, I couldn't if I wanted to. All the other lunch counters serve whites only, and if I integrated my lunch counter, then I'd lose all my white business.
Let's talk about the sit-ins these students have been conducting. You say that there were 3 occasions when they participated in these sit-ins.
Yes, 3 before last Saturday, 13th, the 18th, and the 20th.
You didn't have any violence on any of those occasions, did you?
No.
The young people sat quietly at the counter
anyway.
or tables. I'm sorry?
No physical violence, anyway.
The young people sat at the counters or tables, sat quietly, didn't they?
Yes.
There was no name calling, no threats, no shouting or rolling around on the floor.
Not before the 27th, no, sir.
And what was different 2 days ago was that there were these young white boys and some young men, toughs, I believe you called them. Is that right?
Yes.
You keep calling the defendants, I heard your testimony earlier, Negroes, but there were white students there as well, weren't there?
Yes, there were a few.
And there was no trouble from the white students or the Negro students until the toughs got there. Is that right?
Yes.
The pushing and shoving, that was by the white toughs, wasn't it?
What I saw was, yes.
And the people who got hurt, those were the people, the students that were sitting at the lunch counters.
Yes, what I saw.
The white toughs, they all ran from the police, didn't they?
Yes.
None of the sit-in students ran, did they?
No, they just got back up and sat back down.
They weren't afraid of the police, were they?
I guess not.
As you said, the students got right back up and sat back down at their seats. Is that right?
Yes.
Even the ones who were hurt, the girls who were crying, they all just sat back down on the stools, still waiting to be served.
Yes, I couldn't believe it. Some of them were bleeding, the girls were crying, but they just continued to sit there.
And when the police arrived, they went peacefully, didn't they?
Yes.
You didn't see any of these students throw the first punch, did you?
I don't know who threw the first punch.
So you didn't see any of these students throw any punches?
No, I didn't.
They didn't break anything in your store?
No.
They didn't steal anything in your store?
No.
They just wanted to be served, just like any other person, right?
I suppose so.
You said you knew there was going to be trouble last Saturday.
Oh, yeah. Yes.
And that's because these white toughs were there.
Yes, they were yelling and taunting in the street, and I knew it was just a matter of time.
But there was no police in your store on the prior occasions.
No. No,
They only
weren't.
came in afterwards, after the toughs had run off.
Yes.
No further questions.
All right, thank you, Mr. Henry. You're free to go, or you may remain in the courtroom as you prefer. Mr. Leaver, call your next witness, please.
Please, court, the city rests.
All right. Now we're getting somewhere. Mr. Luby, do I understand you want to call some witnesses?
Yes, yes, Your Honor. The defense calls Lewis Hunter.
All right.
Left hand on the bottom. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may be seated.
What is your full name, sir?
Lewis William Hunter, Jr.
Mr. Hunter, how old are you?
I'm 19. I'll be 20 in June.
Where are you from?
Decatur, Alabama originally. I live here in Nashville now.
What are you doing here in Nashville?
I'm a student at Fisk University, a sophomore.
What are you studying?
Engineering mostly. I'd like to be an architect or an engineer, maybe even a jet pilot.
Please explain to the court what happened last Saturday at Woolworth's at 221 Fifth Avenue North on the 27th.
Well, it all started several months ago. Some people that I knew from Fisk were going to a meeting at First Baptist on Capitol Hill, and they asked me if I wanted to go along. It sounded sort of interesting. I wasn't too busy, so I decided to go. Plus, they said there are lots of good-looking girls there.
I see. What kind of meeting was it?
Well, it was different from regular church. The man in charge, Reverend Lawson, was talking about Gandhi and his doctrine of nonviolent resistance. He spoke about how we could implement those ideas to change things in Nashville.
What all did Reverend Lawson talk about specifically?
Objection, Your Honor. What this Lawson has to say has got to be hearsay. And furthermore, what was discussed at this meeting some months ago is irrelevant to what happened last Saturday at the Woolworth store.
What do you say about that, Mr. Luby?
Well, the evidence goes to Mr. Hunter's state of mind and intentions last Saturday because both are highly relevant to the mens rea of the offense charged, whether he intended to cause or provoke a disturbance.
Well, I'm going to allow a little leeway here, but let's please rush on and get to the point.
So, Mr. Hunter, what did Reverend Lawson teach you and the other students?
That's outrageous.
Order in the court.
Go ahead, Mr. Hunter.
He talked about Gandhi, how he had used nonviolent resistance to help end British colonialism in India, and how Dr. King had used it in the Montgomery bus boycott. We discussed how we might use it here in Nashville to fight injustice. Oh, and Reverend Lawson talked about Jesus a lot, how what he said in the Bible was very similar to the things that Gandhi had taught, like loving your enemy and being prepared to sacrifice yourself for what you believed in.
And how did those meetings with Reverend Lawson lead to the events of last Saturday?
Well, in reference to last Saturday, this went back to my last semester, a little bit before Christmas. There was a discussion among the ministers and students about what we could do here in Nashville to fight injustice. Some of the women from the church mentioned the stores downtown, how they couldn't try on the clothes or the wigs, how they couldn't use the restrooms or eat at the lunch counters. Some of the women from the church mentioned how hard it was to go shopping with little children when they couldn't feed them or even take them to the restroom to change their diaper. So the group collectively decided that a nonviolent protest against segregation in the downtown stores would be a good place to start.
Mr. Hunter, did your parents know about this?
No, sir, not really. They worry about me and think that this all interferes with my schooling. You see, my father, he never had the chance to go to college. My mother either. They want me to find a good career and get good grades. So suppose that they're not very happy that I'm sitting here in court today as opposed to in a classroom.
So tell me about the sit-ins. Was the first one on February 13th?
Yes, the first one was near Valentine's Day. There were about 100 of us there. We went to several of the dime store lunch counters. We did like we were trained. We were dressed in our best clothes. I had on my Sunday suit. And when we went to the stores, we knew that we had to purchase something.
What did you buy?
I think that day I bought a pencil because I had a geometry test the following Monday, and I wanted to get some studying in while we were there.
Who all was with you?
Well, there were lots of people. There were several students from Fisk. There were lots of people from Tennessee A&I, several from the American Baptist Theological Seminary. There were men and women, plus some white students from Fisk.
What did you all do after you made your purchases?
Well, after we purchased something, we went to the lunch counter. I picked up the menu and started to seek service. And then the waitress came over and she said, "Sonny, we don't serve Negroes here. You'll have to go somewhere else."
And what did you say to that?
I told her that my friends and I were customers and we wished to eat something before we left. So then she went and got the manager, and he came and said the same thing. We don't serve colored people here. He then turned off the lights and closed down the counter.
Did you leave?
No, sir. We weren't going to leave until we felt like we'd made our point, or until we'd been served.
What point exactly was that, Mr. Hunter?
That it's wrong to discriminate against Negroes at the lunch counter, to accept purchases from them, but to deny them equal use of that facility.
What did you do while you were at the lunch counter?
Well, like I said, I just was sitting there studying for my test.
Did you all talk to each other or make any sort of disturbance or loud noises?
Well, I'm glad you asked because, in fact, our training dictated that we know. We decided to not talk to each other because we didn't want to make a disturbance. And we didn't want to give anyone a reason to say that we'd been unruly.
Did you feel scared?
Yeah, we were all pretty scared.
When did you leave the counter?
Well, the plan was stay there for 2 hours, then leave for a mass rally at First Baptist Church. So that's what we did.
Did you return to the lunch counters after the first time?
Yes, I did. I missed the next time, the next Thursday, but I was there on the 20th. This time I went to McClellan's, and we followed the same procedure. Go to the lunch counter, first purchase something, and after you purchase something, seek service, and stay put when they deny service.
Did anything different occur on the 20th?
Yeah, there were a lot more people there. More students, more police on the streets, more people taunting and harassing us when we went into the stores.
But no fights?
No, sir, no fights.
Had you been trained for that?
Yes, that was something that we trained for at every meeting. We wanted to make sure that we responded in a nonviolent manner to any kind of provocation. In our training, we pushed, shoved, taunted each other, yelled threats. We wanted to make sure that we were calm so that we could show what injustice looked like.
Tell us about the events of last Saturday, February 27.
Well, this was our largest effort so far. They said there were 350 people who walked from the church to Fifth Avenue that morning. We were divided into teams, and each team had a store and an order. My team was sent to Woolworth's, and so we walked in there. There were two teams. One team laid downstairs, first they made a purchase, went on the stools and sought service. The other team, I included, went upstairs on the mezzanine, first making a purchase, then seeking service. But it was different because it seemed pretty quiet up there. They had closed both registers as soon as we went in, but it seemed like no one knew that we were up there on the mezzanine.
What did you specifically do when you arrived at the Woolworths that day?
Well, because no one was there, I just took out my book and decided to read. One other student was with me. He was from the American Baptist Theological Seminary, and he took out a Bible, and I think he began to work on a sermon.
Did the rest of you all engage, the rest of the students engage in any sort of banter or conversation?
No, we were all very quiet.
You say at first, earlier, something changed from the 20th about what happened on that date and on the 13th versus what happened on the 27th?
Yes, well, this time there were white men and boys who started up the stairs. As soon as they came through the door, they were yelling, cursing, and threatening what they were going to do to us if we didn't stop what we were doing.
Was it just threats?
At first, yes, but then they started to get pretty physical. They were pulling on one girl's hair. I saw them put a cigarette out on her coat. The ABT student, they knocked the Bible out of his hands and started punching him in the face. One of them blew cigar smoke in my face and was trying to push me off the stool.
And where were the police when all of this was going on?
I don't know where the police were. All that was upstairs on the mezzanine were us and the white men.
Then what happened?
Well, the more we ignored them, the madder it seemed to make them. Then all of a sudden, one of them said, "Let's get these niggers." So they took me, threw me off the stool, and here I was on the floor, and they're kicking me in the ribs and punching me in the head.
What did you do to defend yourself, Mr. Hunter?
I did exactly as I was trained. I covered my head and tried to resist their blows just like Gandhi did with the British.
How long did the beating last?
Well, it's hard to say. It's one of those moments where you gain a greater awareness. It's almost as if you're outside of your own body and you're looking from a different standpoint. I was just patient and endured the blows, and as time went on, eventually the men left. And as I got up, I saw them run downstairs.
What did you do then?
Well, I checked on my teammates to make sure that they were okay. The girls, they were crying, but they weren't hurt. And the ABT student, he was bruised, but he seemed to be okay.
What about you? I'm sorry, go ahead.
Well, after we tried to get up from the scuffle, we just sat back right on the stools, did just as we were trained.
What about you? Were you hurt?
Yeah, I had a cut on my head. You know, head cuts bleed a lot, but I had my handkerchief to stop the bleeding. It wasn't too deep. My Sunday suit coat was torn. I was pretty upset about that.
How long after that before the police arrived?
It seemed as though just as soon as the white men left, the police came up the stairs. And as soon as they come up the stairs, they pulled us off the counter and arrested us and threw us right into the paddy wagon.
Had you ever been in a paddy wagon before?
No, sir. No one in my family has ever been in jail.
Were you taken to jail?
Yes, they piling more and more students inside of the paddy wagon, and eventually they took us to a cell.
What happened at the jail?
Well, there were some other people there, but it was mostly students. And as we began to congregate, there was lots of singing and clapping. It got pretty loud at times.
How long were you in jail on Saturday?
I stayed in the jail until Saturday night. They set the bond at $100, but we weren't going to make bond, even when they set it to $5. So eventually they released us to the treasurer from Fisk, Dr. Wright. So I was able to go home to my dorm and sleep, but I really couldn't sleep. We were all really charged up. It was hard not to be.
Mr. Hunter, have you ever been arrested before?
No, sir.
Was your conduct at the Woolworths that Saturday disorderly?
No, sir. We were all very clean, respectful, organized, disciplined, and quiet, just like we were trained to be.
Did you strike anyone?
No, sir.
Did you threaten anyone?
No, sir.
Did you resist arrest or the police when they came to arrest you and your friends?
No, sir.
Did you destroy or damage any property belonging to Woolworths?
No, sir. In fact, the only property that I know got damaged was my suit.
Thank you, Mr. Hunter.
Leaver, you may cross.
Mr. Hunter, you're not from Nashville, are you?
No, not originally. I'm from Alabama.
And lots of these people who attended these meetings and who've disrupted these lunch counters, well, they're not from here either, are they?
I guess some are and some aren't. I don't really know them all.
In fact, some of them are from up north, aren't they?
I guess so.
Like that Diane Nash, one of the other Fisk students here. She's from Chicago, isn't she?
I think so.
And this Reverend Lawson, your leader, he's from Ohio.
At least he went to college there.
And in fact, he's a convicted criminal. Isn't that right?
I know that he was a conscientious objector during the Korean War.
So you went to these meetings led by a convicted criminal and conspired to disrupt these businesses whom you knew would not serve Negroes. Isn't that right?
Your Honor. This is argumentative and irrelevant.
Overruled. Proceed on, Mr. Leaver.
Thank you, Your Honor.
I went to these meetings and we planned protests on how to segregate against the downtown stores. That's why I was there.
Now, Mr. Hunter, tell me, what other organizations do you belong to?
Objection, Your Honor. That line of questioning is irrelevant to the charge of disorderly conduct.
It goes to the man's intent to create a disturbance or to incite or provoke violence, Your Honor.
Overruled.
Mr. Hunter, what organizations do you belong to? Are you a member of the NAACP?
Objection, Your Honor. I instruct my client not to answer those questions on the grounds of his First Amendment right of association.
Your Honor, that's not a sufficient grounds to refuse to answer at this time. If he belongs, if Mr. Hunter belongs to a criminal organization, then he can take the Fifth Amendment. But there's no testimonial privilege for the First Amendment.
Well, I'm going to overrule that one too. Mr. Luby, you can advise your client to take the Fifth Amendment if his answer would tend to incriminate him, but otherwise he's required to answer the question.
So, Mr. Hunter, I'm going to repeat. What organizations do you belong to?
I was a member of a fraternity last year, but other than my church back home, I don't know that I belong to any organizations.
Now, you attended a meeting prior to the sit-in last Saturday, didn't you?
Yes, I did.
A planning meeting.
Planning and training. There were new members there, and we wanted to make sure that they were trained in the ways of nonviolence.
Now, tell me the names of the other students who attended that meeting.
Objection, Your Honor. Mr. Leaver is simply on a fishing expedition, trying to identify the other students who were not arrested. And indeed, he is trying to chill their participation in this movement. My client has a First Amendment right of association. This is inappropriate.
Mr. Luby, this court finds you to be in contempt for continued disobedience to my prior rulings on this issue, and I fine you $10. Unless the answer would help to prove these charges or otherwise incriminate the witness, he must answer the question. Answer the question, Mr. Hunter.
I'm sorry, could you repeat it, please?
My question is, tell me the names of the other students who attended that meeting.
All the people that I know that were at that meeting are sitting here in the courtroom today, and they were sitting in the city jail last Saturday night.
Okay, now you said that you had been trained on what to do when a fight broke out. Is that correct?
Yes, we were trained on how to respond to a violent situation in a nonviolent manner. Correct.
And that was something you trained on several times. Every time you met, I think you said.
Yes.
So you knew there was going to be a fight when you went to these lunch counters.
We knew that there was a chance that we would probably be attacked, yes.
And the more times that you went back, the greater the likelihood of trouble. Isn't that right?
I guess so.
And you knew that you wouldn't be served at the lunch counters when you went back.
Well, that was the point. We wanted to show people how wrong segregation is.
But you knew, after being refused twice before, that they weren't going to serve you this time.
We probably knew that they weren't going to serve us this time either.
And you knew they were going to close the lunch counters just like before.
We knew that's what they would probably do.
But you refused to leave just like before.
Exactly. We refused to be a part of that injustice anymore. We weren't just going to sit there and let them abuse our rights as American citizens. So that's exactly what we did, correct?
So you shut down the lunch counters at all these stores, at Cress, W.T. Grant's, McClellan's, Kane Sloan's, Harvey's, Walgreens, Moon McGrath, and Woolworth.
Well, I was just at the Woolworths.
So you personally just shut down one store?
Just the Woolworths and the lunch counter.
And you personally were just involved in one fight?
No, it takes two people to fight.
Okay, all right, just one altercation then.
I was attacked only once, if that's your question.
Now, you didn't request police protection when you went in there, did you?
My understanding was that several of the students and ministers got together with Chief Hosey to discuss security for the demonstrators.
But you personally didn't request any additional security?
No, sir.
And you don't know the names of the men who you say attacked you?
They didn't introduce themselves. No, sir.
And you couldn't identify them for the police?
The police didn't ask. They were too busy getting us off into the paddy wagon and into the jail.
And you didn't chase these men down the stairs to help the police find them, did you?
No. I got up and sat right back on my seat.
And you would have sat there until the store closed if you hadn't been arrested, wouldn't you?
Absolutely. I would have done just as I was trained to do.
That's all I have of this witness.
All right. Anything more, Mr. Luby?
No, Your Honor. I think the record is pretty clear.
All right, then. The witness is excused. Let's hear your summations if you insist on making one.
Well, I will, if Your Honor, please.
All right.
You know, Your Honor is correct that this case has taken much longer to conclude than it should have. It's a very simple case. The defendant has been charged with disorderly conduct at the Woolworth store at 221 Fifth Avenue North on Saturday, February 27, 1960. And the evidence has shown beyond a reasonable doubt that he's certainly guilty of that charge, and very likely others, including conspiracy to interfere with trade or commerce. Now, Sergeant Watson over here explained how the police anticipated trouble on that day because of the large and hostile crowds that were gathered out there on Fifth Avenue and the events of the prior weekend. He saw the immediate aftermath of this altercation in the store, and it was obvious that the defendant here had been part of that altercation. Now, whether he threw the first punch or the second punch or no punch at all, he went there intending for a fight to occur, that would be the likely outcome of his actions. And a man is presumed to intend the probable consequences of his acts. Lewis Hunter intended to start a fight at the Woolworths on Saturday, just as sure as if he had punched the counterman in the nose himself. Nor was the fight the only disturbance that Mr. Hunter and his gang planned that day. They planned to disrupt a lawful business being conducted in a lawful manner. Woolworths is a private business, and it's free to serve or not serve anyone it chooses. There's no federal, state, or local law against segregation at these lunch counters. In fact, these owners are free to serve whites only, just as the stores over on Jefferson Street are free to serve Negroes only. The fact that these teenagers here don't like it doesn't give them the right to shut down businesses time and time in an effort to intimidate customers and extort a change in the store's policies. If black and white students want to eat together, they can go to Berry Field, which has had an integrated restaurant for many years. But they're not free to go to a restaurant that they know will not serve them and then try to coerce a change by refusing to leave. I submit that in and of itself, that is a disturbance of the peace. Nor was Woolworths the only victim here. Mr. Henry told us about the elderly customer who was frightened and upset by the sudden influx of Negro students and their white supporters. He told about how she won't be back, and I suspect he's right about that. No one in their right mind would step into a situation like this that's a tinderbox just waiting for a spark. If there were young toughs who provided that spark, well, that couldn't have been a surprise to anyone. Now, no one here defends what they did. If the police find them, I'm sure they'll arrest them and we'll prosecute them. But the fact that they were clever enough and fast enough to escape doesn't excuse Hunter and his like from the consequences of their behavior. So the evidence is simply overwhelming. Mr. Hunter went to Woolworths to, as he put it, make a point. He intended to make that point by interfering with a lawful business, by provoking others into threats or violence, and by creating an uproar and attracting attention to himself and his misguided cause. That conduct falls well within the definition of disorderly conduct under Section 26.16 of the Code. He has shown no remorse, and there are no mitigating circumstances that I can see. We submit he is guilty and should receive the full fine and imprisonment provided by the City Code and, if Your Honor feels it appropriate, bound over to the grand jury for consideration of appropriate state charges. Thank you.
Thank you, Mr. Leaver. Mr. Looby, is there anything you'd like to add to your prior remarks?
Yes, Your Honor, there are. Lewis Hunter is an outstanding young man, someone any parent would be proud of. The fact that he stands charged with a crime is not an indictment of him. It is an indictment of the system that would lead to such absurdity. Judge, what is clear from the evidence is not guilt on behalf of Mr. Hunter and these young people. Judge, what is clear, oh, what the?
Watch out, Looby. I'll hold you in contempt again. One more outburst. I won't tolerate it.
Judge, I'm not trying to show contempt for this court. I've devoted nearly all of my life to the law. It has put bread on my table. It has allowed for further education of my people. It has allowed for my people to gain access to votes in the ballot so that they can gain some measure of control over their lives. But the law moves slow, too slow sometimes. These young people, they're tired of waiting for the promises made in the Constitution to come true. They're tired of sitting in the back of buses, tired of going to second-rate schools and being told that their money is good enough at the cash register, but they're not good enough to sit down and have a sandwich at a counter. I'm 60 years old, and sometimes people my age are just too patient. We get used to seeing the old prejudices, the everyday indignities that Negroes suffer. But these young people, they see them afresh, and they intend to do something about them. And I commend them for that. Now, this ordinance Mr. Hunter is charged under prohibits several distinct acts. First, let's just kind of look at them. The first act prohibits violent, tumultuous, offensive, or obstreperous conduct or carriage. There's no evidence of any of those here. Second, loud or unusual noises. The defendant has testified that he was silent, studying for a test. There is no evidence to the contrary. Third, unseemly, profane, obscene, or offensive language. Again, no evidence whatsoever of such language used by Mr. Hunter, only his attackers. Fourth, language calculated to provoke a breach of the peace. Mr. Hunter used no such fighting words. Fifth, assaulting, striking, or fighting another. The only evidence is that the unknown white assailants struck the first blows, the only blows. Mr. Hunter met this violence with nonviolence. Sixth, by the doing of any act or thing likely calculated or intended to provoke or to incite others to engage in riotous, violent, or disorderly conduct, or to wrongfully injure or destroy the property of another. These students had been at the store on 2 prior occasions without incident. They had no reason to anticipate violence for others on that day.
Seems to me that's where you got a problem, Mr. Looby. You claim that your clients didn't anticipate just such a melee as this one that happened in Woolworths last Saturday. When they trained for just such an incident, the testimony shows, for several months. Isn't your client's own testimony proof that he knew he was performing an act that was likely, calculated, or intended to provoke violence and thereby to generate publicity for his cause?
No, Your Honor, I don't believe that's what Mr. Hunter's testimony shows. The fact that they acknowledge the seriousness of their actions and the potential for violence does not mean they intended to cause violence. When I carry an umbrella on a rainy day, I'm being prudent. I'm not trying to make it rain. Likewise with these students, they were being prudent, learning ways to avoid violence or to mitigate it, not to incite it. The disorderly conduct ordinance also prohibits, and I quote, threatening another with bodily harm, demonstrating to provoke a breach of the peace, intimidating any person in pursuit of his rights, coercing a public official, creating a public alarm, or threatening the security or life or property of others, end quote. Again, there is no evidence that Lewis Hunter committed any of the dozen or so acts set out in Code Section 26.16, much less proof beyond a reasonable doubt that he intended to cause a disturbance. There are just no grounds for a charge of disorderly conduct, just as there were no grounds for charging loitering. What did Lewis Hunter do? Just what is his alleged crime? He visited a store and he bought a pencil. He sat on a stool and ordered a cup of coffee. He tried to have lunch with his friends, both Negroes and whites. He studied for his geometry exam and he read a book. And what happened? He was insulted, threatened, thrown to the floor, kicked, beaten, and spat upon. He had his best suit torn and his head bloodied, but he didn't fight back. Not with his fist. He used his head and he used his heart, and he got right back up and went right back to that stool to the lunch counter. You see, Judge, Mr. Hunter knows what he wants, and it isn't a hamburger or a cup of coffee. These young people, they want freedom, and they want equality, and they want their rights as citizens of the United States of America. Judge, that is not a crime. And Mr. Hunter, he is no criminal.
The defendant Hunter will rise. The court has heard and considered the evidence and the arguments of counsel. The court finds that the defendant, Lewis William Hunter, Jr., went to Woolworth's on Saturday, February 27, 1960, with the knowledge that his presence there was likely to cause a disturbance of the peace. He knew from his prior visits that he would not be served and that his presence would cause the closing of the lunch counter, to the detriment of the store and to its legitimate customers. He knew full well from his prior activities that there was a very high probability that his presence would provoke others to violence against himself or his co-conspirators. That is, in fact, what they had trained to do for over the course of many months. Now, it's unclear whether Mr. Hunter struck any of the white youths he's accused of being the aggressor with, but legally that doesn't matter under our ordinance. His very presence at this time and place and in this manner was a disturbance and indeed a provocation. And such deliberate disruption of a lawful business cannot and will not be tolerated in this city. Therefore, the court finds Lewis Hunter guilty of disorderly conduct under Section 2616 of the Nashville City Code, and he is hereby sentenced to a fine of $50 and 30 days in the workhouse. Now, since he's not from Nashville, we'll require a cash bond for any appeal. The bailiff will take the defendant into custody and deliver him back to the sheriff to begin serving his sentence. It is so ordered. Now, gentlemen, you may go ahead and take him, Mr. Bailiff. I'm going to sign the rest of these warrants, and then we're going to take up the rest of these cases 5 at a time so that we can get through them in a timely fashion.
So that was how the first of the Nashville sit-in trials went. Over the course of the week from Monday, February 29th to Friday, March 4th, 1960, Special Judge Harris, Assistant City Attorney Leaver, Attorney Z. Alexander Luby, and the rest of the students' defense team would try a total of 78 disorderly conduct cases. Of these, All resulted in convictions, except for one that was dismissed on motion of the city and one where the defendant forfeited bond for failure to appear. On Friday, March 4th, 1960, at the conclusion of these cases, Special Judge Harris issued 78 new warrants charging the students with conspiracy to interfere with trade or commerce and binding them over to a Davidson County grand jury for state misdemeanor charges. The students declined to make bail, and instead many served their full 30-day sentences while awaiting appeal to the circuit court. After 3 weeks of an informal truce, while the mayor's special biracial committee sought a compromise between the students and the merchants, sit-ins and demonstrations began anew in late March. An informal boycott of the downtown stores by black customers added additional pressure to the merchants and the mayor. On the Monday after Easter, Attorney Looby decided to take up the case of a Minnesota college student who had been driving in Nashville after showing his support for the Fisk students and being charged with a traffic offense. The day after Attorney Looby decided to take this case, on April 19, 1960, his house was bombed. Although Looby and his wife somehow managed to escape harm, his home was badly damaged and over 100 windows were shattered along his street. In response to the bombing, the students decided to lead a silent march to the mayor's office at the courthouse to confront Mayor West. In a famous encounter between students Diane Nash and C.T. Vivian, the students put the question directly to the mayor. Did he think it was right for stores to refuse service to black customers? When pressed, Mayor West said no. He did not think it was right. Mayor West's statements led the headlines the following day, and the lunch counters, already suffering from the boycott, took this opportunity to desegregate together. Although it would be 3 more years before all Nashville restaurants were desegregated, the dam had finally broken and Nashville students had achieved a stunning victory. On the day after the Looby bombing and the dramatic confrontation at the courthouse, Reverend Dr. Martin Luther King traveled to Nashville to address a rally at Fisk University. He told the cheering crowds, "I come to Nashville not to bring inspiration, but to gain inspiration." All remaining charges against the students were dismissed in October of 1960.
Good afternoon, everybody. My name is Paz Haynes. I'm a proud member of the Nashville Bar. I practice law here in Nashville, Tennessee. I am proud to be with you for the next half hour or so as moderator of a panel discussion which will focus on the 1960 sit-ins and the subsequent trials. We just had a dramatization and reenactment of one such trial earlier this afternoon. I would like to begin by introducing the panel. Seated in the center is Justice A.A. Birch. He is a native of Washington, D.C., and was graduated from Howard University with Bachelor of Arts and Juris Doctor degrees. A veteran of the U.S. Naval Reserve, Justice Birch practiced law in Davidson County until his appointment as a General Sessions Judge and was later elected to the Criminal Court. He was appointed to the Court of Criminal Appeals in 1987 and was twice reelected. In 1993, Justice Birch was appointed to the Tennessee Supreme Court and became the state's first black Chief Justice in 1996. He has been a law instructor at Meharry Medical College, Fisk University, Tennessee State University, and the University of Memphis. He has received numerous awards from local, state, and national bar associations, including the National Bar Association Judicial Council's highest honor, the William B. Hastie Award. Our city, in recognition of his long and distinguished career, has honored him by dedicating its criminal and general sessions court building in its honor. To my far right is Citizen George Edward Barrett, a senior partner with the law firm of Barrett, Johnston, and Parsley here in Nashville. He is a trial lawyer with decades of experience and involvement in a number of important cases, not the least of which was his representation of Rita Sanders Geyer in the historic Geyer versus Bredesen lawsuit, challenging racial segregation and inequality in the state's higher education system, and which resulted in historic reforms in our colleges and universities. Citizen Barrett remains active in numerous civic, social, and political causes. And seated to my immediate right is Mr. Gary Shockley, who is a member of the law firm of Baker, Donaldson, Bierman, Caldwell, and Berkowitz, practices here in Nashville, and was the author not only of the script for our dramatization of the sit-in trials this afternoon, but is also author of a fine article, Counsel for the Children, which discusses the sit-ins and was published earlier this spring in the Nashville Business Journal. Now, we have here today two of the counsel for the children that were involved in these trials, and two residents of Nashville, Tennessee at the time the sit-ins took place. And so I would like to begin, Justice Birch, George, by maybe discussing a little bit about what Nashville looked like and the stage in which the sit-ins were set. It was 1959, the end of 1959, the spring of 1960 when these sit-ins took place. Brown versus Board of Education and Brown 2 had been decided. And Nashville had had some very recent experience with the integration and civil rights challenges, with the integration of the public schools in the Nashville Plan. And I was just wondering whether George, Justice Birch, y'all could kind of fill in the blanks for us.
You know, you ought to get two different pictures.
Okay.
So George, you're first.
Let me say I'm a native Nashvilleian. I may be the only one here. I was born there, Mr. Grant, he's a descendant of the Craigheads. I was born in East Nashville and went to Father Ryan and then on to college and went to Vanderbilt Law School at 50 in 1957. Had the privilege of practicing for some 5 years with the finest lawyer I've ever known, Cecil Branstetter, and which gave me a great deal of protection in what I was interested in doing and becoming involved in the civil rights movement. It's nice enough to live long enough to see your ideas vindicated, and not only vindicated, but celebrated. It was not at all like that in 1960, let me guarantee you that. As Justice Birch or Al can tell you, my children, and nor my grandchildren, can understand the world I grew up in. I often tell people that we taught South Africa apartheid, and I say that with a great deal of knowledge and personal experience. To live in a world that was as segregated as Nashville was and the South was when I grew up in the 30s and during the early parts of the Second World War. When I came to the bar, it was equally rigidly segregated. There were a few African-American lawyers you can name on two hands, the two most distinguished being Z. Alexander Luby and Bob Lillard, both of whom were members of the City Council, and both of whom were very vigorous and effective lawyers, but both of whom were denied a membership in the Nashville Bar Association and the Tennessee Bar Association. That bar was broken in the early 60s because to be admitted to federal court, when I started practicing law, you had to have a letter from the Nashville Bar Association. And it was a bit awkward if you couldn't be a member to get a letter from them. So that was challenged, and Judge Miller was the judge who abrogated that rule of having to have a letter from the Nashville Bar Association, because some of the African-American lawyers like Al, or his lordship as I call him, and Avon Williams, younger lawyers, were determined to be admitted to the bar without necessity of the imprimatur of an organization they couldn't belong to. And to see unfold what unfolded in Nashville in terms of challenging apartheid was very thrilling for me, as I know it was for Al and the others. So I'd say it's impossible to visualize the world that he and I grew up in terms of the rigidity of the segregation and the effort to change it and the means that had to be resorted to. Gandhi's, the questions, the ethical questions raised here is, what's the obligation of lawyers in relation to suggesting that you, quote, violate the law or break the law deliberately, and how do you deal with it? The more important question is, how do you as lawyers see your obligation under the terms of the Constitution? What are your rights and responsibilities to challenge those systems? And what are your responsibilities to your clients? And simply to advise them of the hazards of such, and the willingness, if you believe in the Gandhi philosophy of civil disobedience, is the willingness to accept the punishment that goes with it. And it was very inspirational to be involved in that. I was on the mayor's first biracial committee, and Dean Surratt, one of those sacred figures in Vanderbilt, the Surratt Center is named after him, was chairman of the mayor's committee, and Diane Nash was asked to appear before that committee. And this was a remarkable young woman. And I remember when she finished, Dean Surratt looked at her and he said, "My dear, I wish we had some students at Vanderbilt like you," which was very telling because, as I say, Surratt was sort of a sacred name at Vanderbilt for years. So it was difficult, but I was sheltered by a lawyer who had a great deal of compassion and understanding in what I was doing and what I believed in and what he believed in, and it afforded me a lot more latitude than other members of the Nashville Bar. But I do want to say it's great to live long enough to see that idea vindicated and to celebrate it. Now I'll turn it over to you, Al.
Well, George alluded to it, but I'm going to hit it, and that is that there were two nationals, one black and one white, two different societies, two different cities, so to speak, or two different societies in the same city. You know, when you talk about two different cities, one black, one white, I think you need some real concrete evidence, some real concrete examples of how there were two. Well, one was that black women could not shop freely downtown. They could shop, and a concession was made here and there, but not freely because they could not try on the hats, as I understand it, and could not try on some of the clothes, as I understand it. Obviously, there were segregated schools. You couldn't go into any restaurant or other facility for public service and expect to be served. You simply restricted your activities to the things and the places you knew you would be welcome. And that was, of course, your local church and your local civic and social organizations. It was a very tough thing to do, though, if your job, as did mine and George's, take you into the midstream. It was very difficult to do, to interact with a lawyer all day long, battling and toughing it out. And then he says, "Okay, I'll see you tomorrow." I say, "I'll see you tomorrow." And he takes off down West End, and I take off up Charlotte. It's really two different cities. I do want to add that the article by Jonathan Cole, I read it several times, and I was meaning to bring it with me. He's here today. And he was concerned about justice being served. And the article obviously was very accurate, very well done, but on those days, there was no justice. It wasn't there.
Particularly for, if I may, Justice Birch, African-American lawyers, black lawyers at that time. You've spoken before about the difficulties dealing with the bench and bar at that time and some of the bad experiences that you and other lawyers had had.
Well, obviously that's right, but it wasn't justice for us. There was no justice for our clients, because out of the 80, 90 cases that were tried by the special judge, not a single one, not one escaped $10 in cost, or escaped being fined $10 in cost. And this is taking into consideration the differences in where the students were arrested, who arrested them, what they were doing. As you can imagine, the Nashville Police Department, certainly forgot who arrested whom and where you were when you were arrested, and evidence made no difference. And it was truly, truly I hate to say it, but it was just not, justice was not served on that occasion, those occasions. So I'll stop now, if that's all right.
Well, absolutely, Justice Burgin, and if you may continue. We've heard a lot about the sit-ins through, the dramatization today. There have been a lot of articles, a lot of panel presentations, but one of the things that I've been curious about, just from a lawyer's perspective, is what it was like to engage your clients for the very first time. A lot of them had not been to jail before. Many of them had not been to Nashville before. They had been training for months as part of the Nashville student movement, learning about all different religious and philosophical systems that fit into their vision of nonviolence and civil disobedience. And February 27th, dozens of them are taken to jail by the paddy wagon load, and then the lawyers get involved. So what was it like meeting them and talking to them about the case for the first time?
You go
first. It was a revelation, because these students were committed, and if you've ever thought about what commitment is, these students were committed to their cause. Some of them, I think, wanted to go to jail. They felt that they would have not fulfilled their commitment had they not gone to jail. They were so committed that I don't think they could have been persuaded away by any means from that commitment, by what they said, by what they did, by the way they conducted themselves. Truth is, I would have loved to have been with them, sitting in, but I had a family. Brought one of them with me today. She was 2 or 3 years old then. So stand up a minute, Angela. You got it? Okay. Just committed, just pure commitment. I've never seen commitment exist at that level. They wanted to change things. They believed that they could change things, and they did.
Paz, if I could just offer one thing here that I think is a good illustration of that in the trials. One of the students who was charged actually did not participate in the sit-ins. He was a Fisk student, I believe, and he found out his friends had been arrested and taken to jail, and he went down to jail and wanted to see him, and the officer at the booking told him, look, the only way you can go back to see them is for me to arrest you too. And he said, great, arrest me. I want to go back there too.
Yeah.
I agree with Al. It's difficult to imagine people like Diane Nash and James Vell and John Lewis, I mean, these people, these weren't rich kids. These people most of them came from very humble circumstances, like Mr. Hunter, whose parents had never been to college. They had the pressure of their families of, boy, girl, what are you doing down there? I sent you to Nashville to get an education. Here you are in jail. And this is my opportunity, our opportunity for my family to raise my family up from where it had been. And what are you doing down there? And imagine that kind of pressure on a college kid, plus the pressure of the community. What it did was it absolutely crystallized the African-American community in this city. It unified the African-American bar as it had never been unified. That's right, there's no question. I mean, every African-American lawyer in town showed up in court, all, what, 13 of you, or whatever it was. I say you count them. No, you count them almost. 17. 17 on one hand, well, two hands. And it fractured the, quote, white community, for lack of a better word, of those people who were hell-bent to preserve the status quo. And a lot of, this city has been blessed with the mayors it's had in terms of race relations. Ben West was one of the most progressive mayors in the United States, and expressed it there on the courthouse after Mr. Looby's house was bombed. But it brought out a lot of good in the Nashville community, of the residue of good feeling. And you've got a long history. You've got 3 educational institutions in Nashville, Fisk, Tennessee State, and Meharry, and you had the Methodists, the big Methodist complex out there. You had the Presbyterians, you had the Disciples. You've had a lot of religious influence. You had a Jewish community that had a conscience. And these people, some of those people galvanized, and that's what moved the mayor to appoint a biracial committee. But what it did for the African-American bar, and it challenged the Nashville bar. The lack of courtesy shown to African-American lawyers in the courts was imagine calling Mr. Looby, nobody, I mean, it was hard to imagine somebody calling Mr. Looby in court. And some of the judges were really just racist in their terms. And imagine going to court and picking a jury, and they were all white, or being indicted by a grand jury that was all white, being tried by a judge that was white, being tried by a district attorney that was white. And here you are with your lawyer and your client in that atmosphere. And I think some of the young lawyers in the Nashville bar begin to feel that. John Hollins and Bill Willis and some of my contemporaries begin to feel that there was something fundamentally wrong with the discourtesies, the lack of respect, and the lack of understanding of representation of people who've been deprived so long in the history of this country. That is, they talk about the second generation being the greatest generations. I think in African-American history, the history of the sit-ins will be the greatest generation in African-American history. That's my opinion. You may agree with that.
Write your history too.
You agree with that?
I'm gonna write your history too. But I do agree with you.
Oh, well, excuse me, Justice Burgess. Citizen Barrett mentioned the baker's dozen of black lawyers that showed up to defend these 80-some-odd students in court on these misdemeanor charges. The logistical question is, how did you divide the duties? How are they split up?
All right. First of all, it wasn't the baker's dozen. It was every single black lawyer who had been admitted to the bar to practice law in this town at that time.
Okay.
And there were 17, as I have counted. Okay. And 16 are gone. You figure that one out.
I think so.
It wasn't a question of lawyer-client privilege or lawyer-client relationship, because we really didn't have a specific relationship with any one of the sit-in students. As each name was called, or as a name was called, one of us would step up and say, well, I represent Susan Thomas, and the plea is not guilty. Now, if the judge had wanted to engage in even more mischief, He could have said, well, do you know your client? have you talked to her? But none of that happened. But that's what we did, and each one of those students had the opportunity for legal representation. I say opportunity because if there are 80 or 90 cases, each one represented by a lawyer, in each one an attempt was made to vigorously defend, and in each case the outcome was the same, $10 in costs, then you tell me whether they had a good defense or not. The thing I think they had was the knowledge that we stood in solidarity with them and that we were willing to show this city and the world that we were in sync with them. We were behind them no matter what. And you could criticize us if you want to, but we were solidly behind them and they knew it. We raised bail money behind the scenes. Well, not the lawyers, of course. But we helped raise bail money. We got messages back and forth. Took care of some who were sick and such as that. And I think our contribution was not so much to be the roaring lion, the lawyer who adduces such evidence as convinces a judge to turn his or her client loose, not that, but the fact that we stood in solid wall behind these students. They knew we were with them, and the world knew we were with them. Nashville knew we were with them. But like George said, the Nashville Bar, nowhere to be found. Other legal entities, not to be found. It was a time, I guess, of great turmoil for a lot of people.
Including City Judge Doyle, I suppose. I think he was MIA.
I got to tell one story. I was assistant public defender before I was. And I went to judge right after the Supreme Court ruled the Shuffling Sam case. You remember the Shuffling Sam case? Justice Warren wrote that great opinion that you can't arrest somebody for loitering. It's not a crime to loiter. And old Whiskey Joe came in about once every 2 or 3 weeks, was arrested for loitering, marched down before Judge the bar. You stood in city courts. There's no place to sit down. Everybody stood witnessing. Everybody stood. What's he charged with? Loitering. And I said, who represents? I said, I do, Your Honor. Said 10 days and $10, or 50 days and $10, whatever it was. And I said, well, Your Honor, the Supreme Court of the United States has just ruled in the Shuffling Sam case, a brilliant opinion by Chief Justice Warren, you can't arrest people for loitering. He said, who wrote that? says Chief Justice Warren. He said, well, he's got his court, I got mine. Take him away.
Well, it is fair, it would be fair to say that all but one of these sit-in cases was tried by Judge John Harris, who was appointed by Judge Doyle. Judge Harris, John I. Harris. So that says it all.
I think it does. Well, Citizen Bear.
His business, he was a novelty business. I'm not going to tell you what he sold as novelties. Please, no, this.
Okay. Well, Citizen Barrett, you sat through, you observed our dramatization today. What was missing? What did we get?
I thought it was very well done.
Okay.
Don't y'all? It was excellent. I thought I told Ed Yarbrough I was glad we could find something he could do for a change.
What role did he play?
He was an arresting officer. I thought it was very accurate and very well done. And Harris was always finding either Mr. Lillard or Mr. Luby or Avon or Al or somebody in contempt every time they got objected to something. But it was obvious what was going to happen, and the pressure was on the mayor. This was a city court. It wasn't a state court. It wasn't a general sessions court. It was a city court. So these people were charged with violating city ordinances. And the mayor had always had great support. Ben West had a, quote, black cabinet that met on Saturday mornings, back before anybody else was doing anything. He'd meet with Mr. Ferguson, who ran the bank. What was his name who ran the newspaper?
M.W. Day.
Yeah, Day, Mr. Day. Councilman Lillard, Councilman Luby, a couple of people. Phoenix, yeah. They'd meet on Saturday morning. And so the pressure was on him because this was eating away at his basic, one of his basic political supports, the African-American community. And you had this sort of circus going on, which is what it was. Just the buildings, somebody asked me where the building was. It's where the police station is today. It was, you went down right there at 2nd Avenue behind the courthouse, and there was this old dilapidated jail. And the city court was on the first floor, and as I say, everybody sat around, and there was just a bar like that before the court. You stood. There was no seatings or anything. No, the lawyer sort of leaned over, and the judge leaned over, and the witnesses would testify standing up, and all that sort of thing. So it was an informal sort of procedure. But this so focused the community. It so galvanized the African-American community. And, you know, African-Americans, I often call them exaggerated Americans. They're no different than anybody else. They got different political views, social views, economic views. And you had that in the African-American community. But it absolutely galvanized it. I remember Vivian Henderson, who was an economist at Fisk, president of the NAACP branch, who's really the unsung hero of economic boycott in Nashville. He's dead now. He's an economist at Fisk, and he's the one that did all the economic analysis of the impact of the result of the withdrawal of African-American business from downtown Nashville, which was a result of the sit-ins and the strife, and the economic pressure it put on then the big stores were downtown. There were no Kane Sloans and Harveys and Loveman's and all that, all downtown. There wasn't any suburbs. There wasn't any shopping centers. And the economic analysis, and he and I would go to these African-American churches. It was right every night. And I'd sort of explain what I thought was going on in the community. And then Vivian would get up and talk about the impact and the necessity of Mama not to go downtown and buy an Easter bonnet this year, Papa to go downtown and buy a suit for Easter, that sort of thing. It put the squeeze on the merchants who put the squeeze on the mayor, which resulted in ultimately breaking the back of segregation in downtown.
So the trials that went on through March also continued to put political pressure on the mayor. The
trials were the focal point. The trials were what drove the media. You had two newspapers, you know, one, the Tennessean, that was supporting these people. And I remember old man Stallman, who was editor, who published the Banner, used to write the daily column on the front of the Banner, said, from the shoulder, and somebody always said, and no farther up, he charged me one time as engaging in jackassery, whatever that is. But you had this conflict, but it just galvanized the African-American community like it never was before and hadn't been since.
And there was another unfortunate event that happened later that spring with the bombing of Attorney Luby's home. That correct. Also galvanized the community.
That's right. But before that, the organization, in terms of raising bond money, organizing the community, the economic boycott, all that I don't think could have happened without the focus on the trials, which were the drama, which focused the African-American community on the need to unify.
But the bombing itself, in addition to adding to the galvanization of black people, angered many, many white people.
Oh, sure.
And, you know, people on the fence, white people on the fence, sort of torn between doing what was right and what was perhaps acceptable, but the bombing pushed them over. And they came out of the came out of the woodwork, so to speak, to help.
Which led to that essentially silent march.
Yeah.
And that famous moment on the courthouse steps. Attorney Luby was visible for a number of years, had handled a lot of high-profile cases, had been elected to the Metro Council. He'd worked with Thurgood Marshall.
Case down in Columbia and Mink Slide in 46 and race riots down there.
That's right.
He and that's where Thurgood first came to Tennessee. Thurgood Marshall.
That's right. That's right. So, in the wake of all of these events, and then after Mayor West stands on the courthouse steps and says, I believe that, you know, the segregation of lunch counters is morally wrong, or words to that effect. What were the reverberations of that?
Well, it certainly suggested that the policy of the city was to support the nonviolent change of unconstitutional law. And while its impact, I don't think, was immediate, I think you could sort of feel change coming. At least I could feel change coming. People would smile at you, and you'd wonder why. And things around the courthouse, tensions around the courthouse became eased to some extent. And you saw the sign colored and white just went away. No longer there. Didn't take any kind of protest. It just moved on out. And things got better in terms of relationships. And this moved on out into the city with the stores and the shops and economics. And I think the economic part of it was the backbone that when that was cracked, everything else simply followed.
And a lot of movements were sparked similar movements were sparked in other parts of the state, and I believe as a result of that. Chattanooga had their own sit-ins, and Memphis had their own sit-ins, and
once the wall begins to crumble, you know, it's like the leak in the dike. You pull the finger out, and the dike won't be long till the whole thing
like the Berlin Wall.
Yeah, that's right. It's like the Berlin Wall. And then you followed the legislation in the Civil Rights Act of '64, where we dealt with all these, you know, transportation, communications, public facilities, education, Title IX, all the women, Title IX.
Well, what about the lasting effect on the Nashville bar itself? I think Justice Birch, you've spoken about how the courage of the children inspired the black lawyers in the bar, and what type of effect that had.
Well, what effect it had on the Nashville bar? Yeah, generically?
The lawyers in the Nashville community, not the Nashville Bar Association itself, but
I don't know.
Your colleagues, okay.
I don't know. George, I have to answer that. I don't know. Things eased up a little bit, not much.
Okay.
But they eased up a little bit. You could feel that the tensions were becoming less tenuous.
Well, the bar used to be absolutely dominated by, pardon the expression, big law firms. And it was sort of a good old boys club is what it was. I think the growing presence of African-American lawyers, growing presence of younger lawyers, and I was one time. Lawyers coming out, if you'd been in the service and served with African Americans and come back and been educated with them and all that, you didn't have the same feeling that your parents had about that. And a sense that you ask somebody he or she to volunteer his service and risk his or her life for the country, you sure ought to have the same sort of treatment that everybody else does. So I think those things went away, and the increasing presence of women in the bar, I think, helped too. how many women were there in the bar when you and I started? Half a dozen, I'd guess.
Rebecca.
Rebecca and what's her name, with Joe Cummins' office. And there wasn't many. I mean, there were half a dozen women at the most. There were 2 women in law school when I was in law school, all 3 years. But my daughter went to law school 30 years later. 40% of her class was female. Now at Vanderbilt, there's more females now than male. Oh, that's true everywhere, undergraduate school and everything. So those things change, I think, with social pressures and education.
Well, in an earlier panel this month, Diane Nash and James Lawson spoke of their gratitude to the lawyers that stepped up to defend them and stand with them in the sit-in trials. They were young, they weren't of much means, they'd never been to jail before, at least Ms. Nash had not, and to see the lawyers, black lawyers in this town stand up with them, they're very grateful for it to this day, and they were inspired by that. Gary, you've done a lot of research, and I'll leave you to trigger our concluding remarks. What were 1 or 2 of the most interesting things that you took away from your extensive research on this project?
Well, I guess one of the things that was interesting to me as a lawyer is the extent to which, as Justice Birch said, justice simply wasn't available to these defendants in court. But in many respects, I think it was an instance where the lawyers won by losing, by showing up, by showing solidarity, by just as the students were confronting injustice in the dime stores, the lawyers confronted injustice in the courts. And it became clear to those who were willing to listen that injustice and segregation didn't just exist on Fifth Avenue. It was in this courthouse as well. And in a real sense, I think they won by losing. And the charges were eventually dismissed. And that put pressure, as George has said, on the mayor and, as both have pointed out, on people who were willing to listen and who didn't have their mind made up.
Citizen Barrett?
I have no comments. I'm just glad after so many years we've been vindicated now.
And Justice Birch, I'll give you the last word if you'd like it.
Well, I just hope that those of you who weren't there, and I think that covers everybody in the room on that side, will not forget and will pass it on to your children and nieces and nephews and grandchildren who you will find incredulous. They will not believe you. You have to really pound it into them. So I hope that you do that.
I want to thank the Nashville Bar and the Napier-Looby Bar Association for doing this thing. It's a very good program, very helpful. Thank you very much.
Thank you, Citizen Barrett. Thank you, Justice Birch. Thank you, Gary, and thank you, everyone in the audience.
Before we go here today, I'd just like to thank so much the wonderful participants who've made this event possible. First, in particular, these legends of the bar, Justice Birch and George Barrett. You're certainly an inspiration to all of us practicing here in Nashville today. On behalf of the Nashville Bar Association, it's been certainly a pleasure and honor to work on this project in conjunction with the Napier-Looby Bar Association and the Nashville Bar Foundation. And I'd like to thank all the law firms in town who've been very generous in their support, and in particular, SunTrust Bank, the U.S. District Court Library Miscellaneous Fund, and the Belmont University College of Law. Thank you very much.